Exhibit 1, your attachment 3. Intervenors exhibits page 23 on maximum trip generation, the 3 different development intensities. The analysis in these 3 charts refers to the extension of West Kingsfield Road to Beulah Road, as you show in the chart, for the 2.8 miles from Highway 97 to Beulah Road, right?
Yes.
Yes or no? Okay, thank you. This is based on travel on West Kingsfield Road, entirely on road classified as FDOT's category, urbanized area, uninterrupted flow highway, correct?
That is the designation in the generalized LOS tables.
Yes, I see it as a footnote. Okay, you use the LOS standards. Well, I think I asked her. Okay, are you aware that the West Kingsfield Road Extension Project ends just past the gas pipeline easement?
When you say the project ends, I'm not sure what you mean by that.
It stops short of Beulah Road.
That's not what the TPO long range plan shows.
No, but that is what the county's plan shows. Okay, did you know that this project has no county or other funding available for construction?
I don't know if the county has assigned any other funding.
Okay. Since the new West Kingsfield Road extension does not reach Beulah Road, traffic will have to continue using the existing convoluted West Kingsfield Road to reach Beulah Road. They will have to make 2 90-degree turns, travel a long stretch of road classified actually as rural local road on the FDOT functional classification map of July 1, 2014. That type of road has lower LOS limits for each letter grade, right?
Your Honor, I want to object. Again, I'm trying to have less objections because I don't think that objections are always helpful in moving things along. But again, I believe Ms. Blackwell's testifying, and this is not the place for that at this point of the proceeding. So I'm not sure what the question is.
Blackwell? Ms. Blackwell?
Yes.
What were you going to ask Mr. Metcalf?
Well, just to confirm that that type of grading would have a lower LOS limit than he mentioned. That, you know, people will still have to use the current existing road. And not all that road is classified as the category that he has used in his analysis. It is classified, once you get down to the bottom of the stair steps, it starts to be rural local road, which is a whole different set of LOS standards. I'm surprised that there is an exhibit actually which shows the county's project ends. It ends just off the aerial view of the West Marks property. It's not going to Beulah Road. That's been a false assumption the entire time. It will not reach Beulah Road. It will not give them that new safe direct route. It's going to stop in the middle of the woods. So that is what I'm talking about here. I can't.
So what you're doing is you're presenting conflicting information, which you can present in rebuttal, but you're not really asking Mr. Metcalf a question.
Well, I'm trying to look at his analysis, and I disagree with quite a few points in it, and that would be one of them. I think
Well, but your disagreement, I mean, you can ask him if he's aware of certain information, and he may or may not be.
Right.
But your disagreement seems to be based on information that you know, that you have knowledge of or have acquired knowledge of. And other than asking him if he's aware of it or not aware of it, and I think he's answered some of that, the point you need to make is either going to be in written argument, or you can tell me all of what you just told me when you testify on rebuttal.
Okay, thank you. Yeah. All right. Mr. Metcalf, did you consider the traffic increase related to a new elementary school that opened on Kingsfield Road in 2018, the assigned school for a large area of Beulah just south of I-10, who are likely to travel from Beulah Road to Kingsfield Road to get to school? Yes or no?
My analysis, and I addressed this already, is based on a growth projection, which is the standard method for projecting out future traffic volumes.
You're talking about that normal 2%
That's
yearly.
correct. That's correct. And I would also point out that the level of service calculation, as it occurs farther to the east, would potentially be a separate segment of Kingsfield Road, depending on ultimately how the county decides to segment that roadway.
There are actually 3 different types on the length of West Kingsfield Road. I'm aware of that. Thank you. Okay. And also, Navy Federal had a big increase in employees since 2017. Did you consider that?
No, again, the growth projections will reflect an incremental increase over time. Growth projections assume background development is occurring. That's why the trips go up. That's why they increase.
In your analysis, you use a grade of D for level of service. And you say the county uses that as a standard. But in planning ahead, I can't help but wonder why you would use that as a benchmark when obviously D, as in school, that's not a good grade. So for planning purposes, I can't understand that use of a D.
Well, if your question is why did the county use D, D is typically used throughout the state. There are areas where local governments decide to adopt a higher level of service standard, but again, you have to keep in mind, this is not a concurrency standard. So the county's using D as a planning guideline. And the other point you have to understand about the capacity and the demand on this roadway is there has to be a destination for those trips. So just because, you know, you have the school opening up or you have growth occurring with the Navy Federal Credit Union, if there's not a reason for those trips to come down the street toward the project, they're not going to impact that segment. And if your point is correct that this doesn't extend to Beulah, which is not what the county's reports show, but if for some reason you're able to find a document that shows that, that would only further support that there wouldn't be as many trips loading onto the roadway.
Okay, now let's look at Intervenors Exhibit 67, Intervenors page 151.
Intervenor only has 19 exhibits, Ms. Blackwell. Are you looking at petitioner exhibits?
It's Exhibit 67. And on the bottom of the page, it has another page number, 151. It's exhibit 67. It's the FDOT generalized annual volumes for Florida areas.
So this would be intervenor bait stamp 151.
Yeah, the page 151 I'm figuring now is the bait stamp. That's what you mean on that page. Okay. You are aware that Kingsfield Road is not a signalized state road.
Yes. I didn't use the state signalized section of this table.
Well, the 2400/200 coincides with the number on that chart.
No, it does not.
Well, I have that chart here, table 1, generalized average annual daily volumes for Florida's urbanized areas. Are you looking at that table?
Yes.
So when you go to the right side, uninterrupted flow facilities, and you go down to uninterrupted flow highways, D has 24,200, the number you use.
Got a question?
Is that right?
Yes.
Okay.
That's an uninterrupted flow highway. It's not a signalized highway.
Okay. All right. Thank you. Okay, I think these last two questions are probably rebuttal questions. So thank you.
Okay. Now, Ms. Blackwell, I don't want to restrain you from asking valid questions. So do you understand what I said, that you can provide me with information in your rebuttal testimony that are facts that you know or that you've acquired? And if it conflicts with something Mr. Metcalf says, then that's fine, as far as, you presenting me with facts. But you can ask him a question.
I'm sorry, what was that last line?
You can ask him a question, but his answer will be very limited by his knowledge or lack of knowledge of those facts that only you know or that you have acquired.
I understand.
Does
Thank
that make sense?
Yes, that makes sense. Thank you, Your Honor.
Okay, so do you still want to ask or not ask your remaining two questions?
No, I believe they're hinge on a fact that's not completely established. So I'll
Okay,
wait.
okay,
Thank you.
very good. You're welcome. Ms. Rogers, do you have questions?
Yes, ma'am. Your Honor, I'd like to go through some of the things from the testimony first and some questions that came up. If you would look at Petitioner Exhibit 46, and I do apologize, I don't have the bait stamps on those because I have those individual, but this is the West Kingsfield roadway plans, 60% design.
Okay, I'm there.
Okay, and I can share my screen here too. This is the design, and if I scroll down here, you can see that, oops, I'm sorry. It's a big file, so it reloads itself. And I'm going to make it smaller so it won't keep doing that. You can see in the left-hand corner that this is the 60% plans that you referred to in your analysis. Is that correct?
Yes.
Okay. Do you see on the map there, and if I need to make that bigger, but on the map here, Do you see where it says end project, where my cursor is, and then also where it says begin
I'm
project?
in court, John.
Are you able to see that begin
Yeah.
project? Okay. And this where my cursor is going, this 99, this is Beulah Road. So do you now see that the plans that is in Exhibit 46, and I believe the interveners have the same exhibit somewhere, I'm not sure, at least I saw it at one time. This is the actual road that's being designed, and it's not funded yet. It's only funded for design. So do you see that there?
I see that one page that you're showing me, but the tables that we were referring to that provide the capacity that are in the actual long-range plan indicate that the roadway is planned, and that was my testimony, that it's planned to extend to Beulah Road.
Well, there was a preliminary plan, but if you look on page 3 of this same document, isn't this similar to the documents that you had as exhibits in your report for the
Yes, but
Westmark?
sorry, I didn't mean to interrupt you.
That's fine.
Yes, the difference though is that you're comparing how far they have proceeded with the design versus the ultimate length of the roadway that's planned.
Okay, do you have any plans for the rest of the roadway? Because I've not been able to find those. Do you have those as an exhibit or as some type of documentation?
You mean design plans?
Yes.
No.
Okay, so at the current time, to your understanding, the 60% design that I'm showing on here is what you were assuming went all the way to Beulah Road?
No, I never testified that it went to Beulah Road. I testified that the TPO's long-range plan had planned for the roadway to go to Beulah Road.
Okay, and it's listed as a need, but not as a current project. Is that correct?
I would describe it differently than not as a current project. What I would describe it as is it's shown as the need in the need part of the long-range transportation plan, and then it shows what you're referring to, I think, is that it's not funded yet in the cost feasible plan, but the costs are projected out for what it will cost, which is what the statute requires, that we coordinate and address the need for long-range planning, which is what has been done. And what I've tried to explain is that the county need not fund the entire project in order for there to be an improved roadway available to the Westmark property. That's only a $1.5 million improvement. If the Westmarks or another property owner in the future that owns that land, if it were ever sold, anyone that owns that land that wanted to go forward, if they were ready to proceed, they would have to fund an improvement if it hasn't yet been funded by the county.
Okay, so your tables that Ms. Blackwell was asking you about, they are the assumption of stopping here past the gas line or going all the way through on the extension?
The capacity would not change. The termination point doesn't really matter, or the capacity determination.
So the original road has 290-degree turns, is that correct?
When you say the original road,
the
you
original
mean,
in the current state that it's in now.
yes, it turns.
It twice 290-degree turns, right?
Mm-hmm. Yes.
So the traffic is traveling on the existing Kingsfield Road. How would this extension that stops out past the gas line help relieve capacity at all when you're doing your greatest use or your most intense use projections?
You say relieve capacity. It's not that it's relieving capacity.
or allow, or supply capacity maybe is a better word.
That's a better word. And when the roadway is funded, when the roadway is expanded, it will achieve those capacities. It will achieve the 24,200 capacity that's shown in the county plan, as well as the DOT generalized tables.
Okay, but only when it's extended all the way to Beulah Road, you're saying?
No, I just testified that the capacity wouldn't change whether it's terminated at the current point that you're showing on this graphic, based on the amount of design that's occurred. This is how much design the county has done of a longer facility. The facility itself would still have the capacity at 24,200.
Okay. All right, I'm going to leave that there. Is, in your opinion, as a planner, you talked about hot growth areas. Could you tell me what a hot growth area would be?
Well, the example I think I was giving in my testimony is if you have an area that has a lot of growth, and this was in discussing whether the assumption of a maximum theoretical density should be used based on the land use category. The example I gave is if all of the properties around the parcel that's in question were all developing to the maximum, and the area is a high growth, just maybe I should use the term high growth, that there's a high growth in that area and all of it's occurring at the maximum, it would be a reasonable assumption that an infill parcel in the middle of all of that high growth occurring around it should be reasonably assumed to also develop to the maximum like all of the other properties around it. And I was contrasting that against this situation where that's not the case, where you don't have properties developing to the maximum.
I would like you to take a look at Petitioner Exhibit 53. And Your Honor, I don't believe this has been accepted into evidence. I have a larger version of this that I have for rebuttal, and I can wait till then if you'd want it. But for this particular witness, I would just like to show him. And now I know it was contested because they said that it went to October 20th, which was post dates, but the majority of these, just like the TPO report that Mr. Metcalf used, the majority of these projects have been on the development review from way before the adoption date of this amendment. So I would like to ask you to reconsider, or I think you kind of set it off to the side. And since so many of Mr. Metcalf's exhibits were accepted because the information existed, even though a couple of these projects might have gone on, they might be newer. The majority of them were before the adoption date. Would it be okay to put this into, be accepted as an exhibit?
The objections were lodged. Remind me of them, Mr. Pepler or Ms. Fox. This would be Petitioner's Exhibit 53.
Yeah, from my recollection, there was a question with relevance and also with the data having been existing post-adoption. So the issue with this exhibit is what projects were in existence prior to June 4th of 2020 or subdivisions. And the second issue would be what relevance do they have with regard to the opt-out of the Westmark property and the other two parcels?
Well, if I could answer that, I believe that if we're talking about estimating growth areas and hot growth areas, obviously Mr. Metcalf is not from here. So I believe that this exhibit would show that this is indeed a hot growth area. And if that Kingsfield Road would be extended to Beulah Road, it would make it even more open to the entire Beulah area. So that's where my thinking was on that.
And what relevance does that have to whether or not they meet the criteria for opt-out in 163?
Mr. Metcalf's testimony was it was not appropriate to assume that there will be a build out unless it was a hot building area. And Mr. Beach has testified that it is a hot building area all around there. So I think to establish more than just hearsay of Mr. Beach, establish that this is indeed a high growth area and that maybe 2% calculation for growth is a little underrated.
Well, Judge, I think she needs a planner who would make that assumption and then make that opinion that all these subdivisions surrounding West Kingsfield Road somehow would have an impact on the withdrawal of the Westmark property from the sector plan. And just having her throw this map up, and I don't mean try to place this map in evidence without any expert opinion, I think it's irrelevant.
I'm trying to ask an expert. That's what the purpose of this was, to ask him. Obviously I couldn't afford a planner, I couldn't afford a lawyer, but I am questioning, cross-examining statements made by the intervener's expert witness that said it's not appropriate to assume that there will be a build out unless it's a hot building area. So I wanted to show him this exhibit and ask him if this would change his mind about the growth in this area.
Mr. Metcalf, can you answer that question? Would this exhibit change your mind about the opinion that you have?
No, there's not enough information about when these units came online. And my point was as to whether we could expect the property to develop to the maximum theoretical allowance by the land use category. None of the information on this exhibit confirms whether these were built to the maximum or not. Moreover, there's no indication that these various locations have loaded trips onto Kingsfield. If they had, you would expect a much higher growth rate, and we only have a 1.4% growth rate on Kingsfield. So I think that really documents, if anything, the opposite of what they're suggesting.
So Mr. Metcalf,
okay, hold on,
sure.
Ms. Rogers. What does DRC stand for?
Development Review Committee. So these are projects that went in front of the local to get a permit, a development order.
Oh, okay. And none of these projects have a date? I can't read anything on this exhibit.
No, ma'am. No, Your Honor, they do not. They
Okay,
just,
so I really cannot tell anything from this project.
I'll withdraw this exhibit in rebuttal. I have the whole entire thing that does have a date on it, and so maybe that would be more acceptable to you. So continuing on my questions then.
Okay, I will note for the record that petitioner has withdrawn petitioner's exhibit 53, on which I had earlier reserved ruling, but since she's withdrawn it, I do not have to rule on it. Go ahead, Ms. Rogers.
Thank you. Okay, I think I'm just going to go to my other, and then I'll go back to some of the testimony from today, but my previous questions. So, Mr. Metcalf, you stated in your report that you were hired by the interveners. Is that correct?
Yes.
When did the interveners contact you?
Let me think about that for a moment. Probably should have looked that up anticipating the question, but I didn't. I want to say maybe July or August.
Okay, so you received a call from them?
No, I believe that Ms. Fox had initially contacted me on their behalf.
Okay, Ms. Fox. And did you agree then on that phone call to provide testimony?
I agreed that I would look into the matter some, which I always do before I accept clients. And then we go through our typical process of running conflict checks and also eventually executing an engagement letter.
So when was it that you agreed to take this job?
I don't remember the exact date of our engagement letter.
Do you have a rough idea? Soon after that, or?
Like I said, it was, oh, yes. So it would have probably been within a week or two of our initial call.
Okay. What had you reviewed prior to saying yes?
Well, we reviewed the.
I don't mean to interrupt, Ms. Rogers, but why is this necessary and how is this going to help me?
Can I ask the questions and
Where your line of questioning has to have a point. What's the point you're trying to make with me? I can tell you whether or not.
Obviously, I'm sorry, excuse me, I didn't mean to interrupt you. Obviously, I'm establishing that, well, and I could ask him this question, did he have any role in preparing the subject amendments? Is that a fair question to ask?
Well, you can ask him that. You don't have to lead him down the road. You could ask him, when were you hired and was it before or after the amendment was adopted? And did you participate in any way in preparing or advising the Westmarks prior to June 2020? You can ask him that. And can you provide that answer, Mr. Metcalf?
Yes, I can.
Go ahead, please.
I was hired afterwards. I didn't have any involvement in preparing the plan amendment application.
Okay, so you knew you were being hired to defend the amendments in a hearing?
No, you're making an assumption. My contract was to evaluate the plan amendment, give them my compliance opinion after evaluating it. And if my compliance determination supported their case, then phase 2 would be for me to prepare my report and ultimately testify.
Okay, so in the reading your resume, which you have as an exhibit in your report, it looks like the last 16 years you've been working in the private sector. Is that correct?
Yes.
What percentage of your work do you do on behalf of developers?
Developers,
Private developers?
probably 80 to 90%.
Okay, and you are the author of this Exhibit 1 for the Intervenors Westmark Comprehensive Plan Amendment Compliance Evaluation?
Yes.
Okay, did you write it all? Or
Yes.
did anyone else? There's no other authors? Okay.
No.
All right, in Petitioner Exhibit 39, the respondents emailed us on November 2nd saying that you had not yet completed your analysis before the upcoming hearing on November 12th. If we want to look at that.
Not sure I'm on the right.
Petitioner.
My 39?
Yes.
What I'm looking at is an email from
yes, that's it. That's it. Correct.
Charles Pepler to,
Okay.
or excuse me, from Miss.
It's two,
Yeah.
right, from Mr. Pepler to the
Right.
two of the petitioners. And on there, Mr. Pepler said on November 2nd that you had not completed your analysis. It was still a work in process. Do you remember when you completed this analysis?
Well, obviously before the hearing, probably at that point, I was just going through some final editing.
Okay, in your list of documents that you reviewed, number 5, you listed all the documents that you reviewed to come up with your report. And document number 5, you said that you looked at the Midwest Sector Plan adopted on September 15th, 2011. Is that a typo, or should that be the DSAP documents that were passed on September 15th, 2011?
I'm sorry, where are you reading?
I'm on the first page.
Of my report?
Yes, actually, it might be page number 3. I have a paper copy. I'm sorry, I'm not
Okay.
looking at it. I'll try and get on the same page with you.
All right, I'm on
So
page 3 of my report.
yes, page 3 of
Okay.
your report. Yes.
Okay.
Number 5. The document, you listed it as Midwest Sector Plan adopted September 15th, 2011. Would that be the final DSAP document that you're referring to?
I'm sorry, I don't see where you're referring to number 5.
On
Mr. Metcalf, it's actually Bates number 3, and it's your page 1.
Oh, okay.
I'm sorry.
Okay.
Thank you, Mr. Pepler.
Okay, now I see where you're referring to. And your question?
Okay, you listed it as the Midwest Sector Plan, but wasn't that the DSAP document that was passed on September 15th, 2011 as ordinance 2011-29?
Would have to, I would have to go back and look at the ordinance.
Okay, and I do have that. Okay, I do have that ordinance here. All right, well, we'll just leave that for now. In your report, right at the bottom of, I guess it would be page 4, Bates stamp page 4, you said you put a disclaimer in your report about not being a lawyer. Why did you put that in there?
Because in litigation cases, the ultimate legal conclusion is the role and job of the judge. And so as a planner, I interpret statutes, I evaluate factual information, and I apply the statutes in considering that factual information. But I'm not attempting to reach an ultimate legal conclusion because that's ultimately reserved for the judge. That's the point of the hearing.
So, but you did make quite a few legal conclusions in this report, didn't you?
No, I don't think so. I mean, I think at the very end, I think I said something to the effect that my findings would support a, let me just see how I worded it at the end. So I said, the plan amendment is supported by adequate data and analysis and is internally consistent with the goals, objectives, and policies of the comprehensive plan. And then I said the plan amendment complies with all statutory provisions cited in the petition. And the reason that I reached that conclusion is the two main areas, data and analysis and internal consistency, were the issues identified in the petition.
Okay, back on Exhibit 1, just to complete this line of thought here. Exhibit 1, your report, which would be Bates Stamp 4. You said that these legal conclusions were offered in an understanding of how your analysis was done. Is that correct?
Well, no, I didn't say they were legal conclusions. I said that to the extent any of my opinions are presented in a way that someone might try to characterize as a legal conclusion, that their purpose was to assist the judge in understanding my analysis and the application of the statutes.
Okay, thank you for that clarification. Any of these opinions that you had, which I still feel like some of them are, obviously they're your opinions and you're not saying it as a lawyer, but they are conclusions. Are there any, have they ever been accepted by an administrative law judge?
Has what ever been accepted?
The opinions that you expressed here in this in this report.
Well, this report hasn't gone to any other ALJ.
No, but did you base your opinions that you have here? Do you have any, or are they based on case law, or what are your opinions based on? I guess is what I'm asking.
Well, you'd have to ask me about each particular provision.
Okay. Okay. In section 3 of your report, which is Bates Stamp 5, under sector planning process, you write about the statutory framework and where you quote 163.3245. I guess it said paren 3. I'm learning from you guys. So this analysis here was written by you. Is that correct?
Yes, I wrote everything in the report.
Okay. When you said that you talk about sector planning encompasses 2 levels here, one being the master plan and one being the local development order. Are you aware that when Escambia County passed their amendment, their comp plan amendment for their DSAPs, they did not follow this this statute?
Well,
Go ahead, I'm sorry.
Is that the end of your question?
Yes,
So I think I testified earlier in the proceeding that the county had followed the procedure prior to the change in the statute. And so as a result, in 2011, the county had adopted the DSAP based on the previous statutory framework.
Okay, so I'd like you to look at Petitioner Exhibit 6, which is this ordinance where they passed the 2 DSAPs as a comp plan amendment. So it's labeled Ordinance 2011-29, September 15th, 2011. So it starts out with the minutes from the county commission meeting, and then really the second page has the ordinance there. Do you see that? Ordinance number 2011-29.
I do.
Okay. I want to share the screen just for everyone else. So you can see the date of this was September 15th, 2011, and you can see that in the actual, if you scroll down to, let me find it here. Okay, if you go, I'm sorry, it's right there on the first page. The third whereas paragraph, they actually quote the statute 163.3245 paren 3, and it is the correct current law that says the two-step process is to adopt a long-term master plan, and number 2 would be adopt by local development order 2 or more detailed specific area plans. Do you see that?
I do.
So even though the law had already changed, if you scroll down to the second page, number 2 on that next page, it says this ordinance satisfies the requirement for adoption of detailed specific area plans by local development order as contemplated in 163.3245. So reading that, would you agree that this probably was adopted after the law had changed?
Yes.
Okay. If you read that next section, section 4, adoption of the DSAPs there, it says the DSAPs attached to this ordinance are hereby adopted and property owners, and then it goes on to say about the property owners in the DSAP. But if you scroll down past that, past the ordinance, there is an actual copy of the DSAP document. Are you familiar with a DSAP document?
Yes.
Okay, so just to recap, the Escambia County did not adopt their, and this is something that obviously I found out as I did my research, did not adopt their detailed specific area plans as development orders, even though the law had already changed requiring them to do so. Is that correct?
Yes, that's correct. That was my the gist of my previous testimony.
Okay, so adopting them into the sector plan as a plan amendment makes them part of the comprehensive plan. Is that correct?
Well, I don't agree with the way you describe them. This document is adopted as part of the sector plan, but
No, I'm sorry, not as the sector plan, as the comprehensive plan. If
the
I
second part of what you said, yes, this let me just go up to the
if we go up to the first page of the ordinance again, on section 3, legislative findings. Says the DSAPs attached to this ordinance are consistent with the goals, objectives, and policies and long-term master plan for the Midwest Escambia's optional sector plan contained in the comprehensive plan. So these were adopted as plan ordinance, and we just established that they were found to be consistent with the rest of the comprehensive plan. Is that correct?
they were, yes. I mean, the legislative determination, section 3 says that they are consistent with the goals, objectives, and policies and long-term master plan for the Midwest Escambia County optional sector plan contained in the comprehensive plan.
Okay. All right, and just real quick while we're here, so we don't have to go back, section 4, do you see where it says the build out date is good until December 31st, 2035, right?
I do.
Okay. All right, on page 3 of your report, you talked about the long-term master plan that Escambia County passed by adopting ordinance number 2011-3 on January 20th, 2011. That's in the top part, right underneath the talking about the sector plan ordinance. Do you see that?
Yes.
Okay, let me see if I'm sorry, I'm going to get to that so everyone else can see it. Okay. And you noted in your footnotes that this January 2011 ordinance was a remedial ordinance because the optional sector plan that was adopted previously was found to not be in compliance. Is that correct?
Yes.
If you look at, okay, I'm going to skip some of this. Excuse me, I'm sorry. Well, let's go ahead to Petitioner Exhibit 5. I just wanted to, I think this is important. If you go to Petitioner Exhibit 5, this is the stipulated settlement agreement from January 20th that we just referenced. And I don't have a Bates number, but if you go down to page 18 of that, this is Petitioner Exhibit 5. You can see this is a statement of, this was from DCA, statement of intent to find the comprehensive plan not in compliance. I just wanted to show you what that was. If you go to the next page, 19, there are some consistency problems with the optional sector plan. So just so you see that, and then skip down to page 22, so 3 pages down. And I just wanted to ask you.
When you say 22, I'm not following your page number references.
I'm sorry. It says I don't have them Bates stamps. I apologize for that. So let me see if I can. It looks like this.
Okay.
Okay, so it talks about the conservation area, and it talks about the long-term concept. At the bottom of the page, it talks about the adopted Exhibit D, the long-range conceptual framework map that you talked about in your report. That's why I'm talking about this. But in this report put there about, you mentioned some of this today in your testimony about being environmentally sensitive areas and things like that. So there were several versions. I guess my questions, I'm trying not to testify. My question to you were, there were several versions of the long range conceptual framework map. Is that correct?
Not sure what you mean by there were several versions. This ordinance included the ordinance that transmitted the plan amendment that was found not in compliance included the conceptual long-range framework map, and then when they adopted the remedial amendment, it was the same map, only there was the only thing that's different is they took the exhibit number off, or the exhibit letter. So it was the same map, but originally described as Exhibit D. And then for whatever reason, they no longer included the exhibit reference in the remedial.
Okay, but they also, in this document right here, they talked about the map did not identify the conservation land uses. And so there were things that changed. It wasn't just this, not lettering. Is that correct?
No, I testified it's the same map other than the Exhibit D difference.
Okay.
That they put a label on it. Just because the department raised an issue doesn't mean that the map was necessarily changed.
Okay, well, let's look at Petitioner Exhibit. This would be the 1-7. This is the Chapter 16 from the Escambia Comprehensive Plan. So Petitioner Exhibit 7. this is some of your testimony in the beginning. You said that you're talking about the conceptual long-term build out in objective flu 16.1, and flu 16.1.1 is the long-range conceptual framework map attached and incorporated in this plan as Exhibit D. Is that what you're referring to in your report?
Yes.
Okay. So after the county, sorry, I didn't mean to make that big. After the county passed the long-range concept, or had that long-range conceptual framework map adopted, there were other maps that were adopted after that. Is that correct?
I'm not sure when you're talking about.
Okay, well, in chapter 16, I'm trying to get to the next steps. It talks about the different processes. I'm gonna get past this real quick. Okay, I'm sorry, page, same exhibit, chapter 7. This is chapter 16 of the comprehensive plan. It's my page 10, but at the bottom of the page it says comprehensive plan 16, 10, page 10.
I'm looking at your shared screen.
Okay, great. So there are several steps after the conceptual framework where the county went ahead and developed the specific area plans. They had the DSAP boundary and determination analysis. Then they did the conceptual DSAP and the preliminary DSAP. And then of course we just looked at the final DSAP and the final DSAP and the land use. The long-range conceptual framework map does not determine the land uses. Is that correct?
In what document?
In present day, the long range. Would you agree that the long range conceptual framework map was just that? It was a conceptual map when the master plan was done as an overarching vision until the rest of the land uses, until the DSAPs were developed?
Well, it is the map that's actually adopted as part of the optional sector plan and adopted into the comprehensive plan. And,
Okay.
it establishes the land uses as they're presented in the comprehensive plan.
It was the overall vision, but it is your testimony that it is the conceptual framework map that establishes the land uses?
Yes. In the comprehensive plan.
In the sector plan.
The DSAP, well, in the sector plan is adopted into the comprehensive plan.
Yes. So are the DSAPs, aren't they?
Let me just finish that.
Sure.
So the sector plan, as it's adopted into the comprehensive plan, includes a series of policies and the conceptual long-range framework map. And then the statute requires that the DSAP must be consistent with that sector plan. So the sector plan controls. The DSAP has to be consistent with the sector plan.
The sector plan is comprised of 2 levels according to 163.3245, correct?
No, the process includes 2 steps. The DSAP has to be adopted by, and I'm talking about the current statute, has to be adopted by development order, and it must be consistent because it's a development order. It must be consistent with the sector plan as it's presented in the comprehensive plan.
All right. If you look at petitioner exhibit 66, which is the sector plan Florida statute 163.3245. And I'm going to share it if that makes it easier for anybody. Okay, just give me section in parens 3, I guess it's called, right here. The sector planning encompasses 2 levels. The two levels, would you agree, are the adoption of a long-term master plan for the entire planning area, and then also adoption of the local development order of
Yes,
2 or
but-
more detailed.
But it doesn't say sector plan. It says the sector planning encompasses 2 levels. So it's a process. And the first step is you adopt a long-term master plan as part of the comprehensive plan. And that long-term master plan consists of the policies and the conceptual framework map that I just mentioned in my testimony. And then the second step of the process is you adopt a DSAP by pursuant to a local development order.
Right, but we've already established that Escambia County did not do that. They did it the other way. They did it as a comp plan amendment. Correct?
Yes.
Okay, but there are 2. Is it your testimony that there are not 2 parts to a sector plan, both the master plan and the DSAP? Are you saying that the master plan is equivalent to the sector plan?
The long-term master plan is the sector plan. And the long-term master plan consists of 2 parts, the set of policies and the framework map.
Okay, let me move on here then. Okay, Mr. Metcalf, when you reviewed the staff analysis when you were preparing for this case, did you find any type of environmental or natural resource study or any data analysis done by Escambia County staff about natural resources or the habitat areas or the wildlife?
I think they may have made some general findings. I'd have to look at their staff report.
Okay, let's look then real quick. If we go to the adoption packet for the second exhibit for the interveners, I'm sorry, I couldn't think of the word. If you go to, find the staff report real quick. Well, while I'm here, I wanted to, if you go to Bates stamp number 0101, as I'm going through this, just to save time, I'd like to.
Judge, I don't know where Miss Rogers is. I'm sorry.
I'm sorry, here I am. I'm on Intervenor Exhibit 2, Bates stamp 0101. Your testimony previously was that there was no evidence that there was any type of waterways or tributaries in this is sideways view of the Westmarks property. I don't know if you can see this word right here. If I make it bigger, it says tributaries, and these are all different waterways. I'll go smaller so you can see what they are. Have you not seen this document in the adopted package? This one says Perdido River, South Basin, 11 Mile Creek, South Basin, and then these waterways here. This is on page 101 of Exhibit 2 of the adoption packet.
Can you turn it on your page?
I don't know how to do that. It's just in that package. I can make it bigger. Do you want me to make it bigger?
Sure.
So the print isn't wonderful. I believe this was submitted by the interveners, but here is the outline of the Westmark property here sideways.
And I don't see it. Is there a label that you're pointing to for that
Right.
that describes?
This says tributary right here, this says tributary, this says tributary here, and then there's these, let me see, it's not letting me move these when it's so big. Oh, sorry. I'm going to make them smaller. And then these labels here say Perdido River South Basin and 11 Mile Creek Basin.
Yeah, but that, what you're referring to there is not on their property.
No, but these are flowing onto their property.
Well, I'm not certain that those are indeed intended to represent a creek. I'm looking at the aerial. I see a lot of, I'm looking at a different aerial and I see a number of what appear to be dirt roads. And I think that what you're looking at is a dirt road. If you go to my report and you look at, say, attachment 6, you'll see that the location of what you're pointing to appears to coincide with what are dirt roads on the aerial.
Okay, and while we're in this application here, I just wanted to point out too, these, this is the interveners, I imagine, put this in their application, but this is a piece from, we're on same exhibit to Bait Stamp 0111, and this is a list of residential land uses from the Midwest Sector Plan DSAP final document. If in reading the application and the analysis by the staff, and we can confirm that later on, the Westmarks have their parcel is in 2 different parcels, M25 and M26, M standing for the Muskogee DSAP. I just wanted to verify with you that they are listed here as conservation neighborhood. You indicated that they could be something else other than conservation neighborhood, but they are listed in the DSAP as conservation neighborhood. And those are the land uses that are assigned to their property. Do you see that?
Yes, but I think your implication is that my testimony was not correct. And my testimony was that the conceptual long-range framework map shows that the designation on the property is suburban / conservation subdivision or conservation neighborhood. What you're looking at is the DSAP.
Right.
Not,
initially,
not the conceptual framework map.
Right. Initially, I agree with you. Initially, the long-range conceptual plan had mixed for some of those areas, but then when they were refined, then that changed. But we'll just leave it at that.
I disagree with you. It didn't. If that's a question to me, this is difficult because you're making statements. But
okay,
if that's a question to me, I disagree with that. The DSAP cannot change the conceptual long-range framework map. It's a different document.
Okay. No, we'll agree to disagree on that. If you look on page 0114, the DSAP overlay right there says wetland conservation neighborhood, and this is for their application, and the applicant included this in their application to opt out of the sector plan.
Again, that's referring to the DSAP.
Okay, so you're saying that the land uses, I shouldn't put words in your mouth, is it your testimony that the land uses in the DSAP are different from those in the long-term conceptual, or can be different than those in the long-term conceptual overlay?
The DSAP map has to be consistent with the conceptual long-range framework map.
So those listings I showed you of M25 and M26 being in the conservation neighborhood land use designation, are you saying that's inconsistent with the
No,
conceptual framework?
no, I'm not saying it's inconsistent. My earlier testimony was there were two options that were given by the conceptual long-range framework map, that the DSAP could designate it as conservation neighborhood, or it could designate it as a suburban village. And so in the DSAP, they implemented it by designating it as conservation neighborhood, which is fine. That's consistent, but that's consistent with the conceptual long-range framework map. But when we're talking about what is the change in land use, the change in land use is from the conceptual long-range framework map to as a result of the opt-out to the MUS, the mixed-use suburban.
So is it your testimony that right now the Westmarks property, before it is allowed to remove itself from the master plan, it is in the new suburban conservation neighborhood land use? Is that what your testimony is?
Yes, that's the designation that's shown in the sector plan.
That's the designation that was shown on the initial long-term conceptual framework map.
That's not just initial, that's what's in the comprehensive plan.
Can you show
But
me?
I'm not
Can you show me?
disputing.
Can you show me what page it's on in the comprehensive plan? I don't believe there's any maps in the comprehensive plan, but I may have missed them. What page would that be on?
Rogers,
This is an important point, Your Honor.
why? Tell me why.
Because this is how he based his testimony. He based his testimony on the long-range conceptual framework map, and this is not what their land use is. And the county has never said it was based on the long range. The county has used the final land use plan, which is the exhibit. It's the map that is found on, I believe it's page 30.
Why is that important?
Because the county in their ordinance, and I can go to the amendment and we can look.
Why is it important? How does it affect my decision whether or not to approve the change to MUS?
Okay, because this is a request to remove itself from the master plan is being processed as a comp plan amendment, and the comprehensive plan has the sector plan, master plan, and also has the DSAPs approved. And that's why in chapter 16.6 with section 5, it talks about changes to a DSAP, because the comprehensive plan, the DSAP has those requirements when you remove any parcel from the DSAP, because the DSAP is adopted into the comprehensive plan. They did not adopt it as a development order. Then you have to make sure it's still consistent. If you are to take something out of the master plan.
Consistent with what?
With the sector plan, with the master plan, it has to still, it cannot violate those principles.
We've had this argument before. It is illogical to tell a property owner they can opt out of certain requirements, but still require that they comply with those requirements. That's a very circular and illogical argument. And I assure you that I will not be interpreting the comprehensive plan in that manner.
But that's not what I'm saying. Yes, that's not what I'm saying. I'm not saying that they would still be under the development standards of the sector plan. That's not what I'm saying. I'm saying just exactly what the wording says on the page. It says, and this is not just for the sector plan.
But also, this is legal argument. You need to ask Mr. Metcalf a question. You can make your arguments to me in writing.
Okay, that's fair. That's fair. Okay, let me go back to my questions here. Was any type of, Mr. Metcalf, was any type of analysis okay, the properties that are surrounding these subject parcels are still in the conservation neighborhood, is that correct? The ones that are still in the sector plan?
Yes, this amendment affects the Westmarks property only.
Okay, so in chapter 16, they talk about that there's a more environmentally protective development pattern. So my question to you is there any type of analysis that you did or the county did to show what changing the density to the maximum amount of 25 dwelling units per acre would have on those properties that remain in the sector plan in conservation neighborhood?
Yes, I already testified that the property that has been changed or opted out and changed to mixed-use suburban has appropriate character for the designation, for the comprehensive plan amendment designation of mixed-use suburban, and that there's opportunities through the county's development process to to buffer additional to buffer habitats that are around the property. There's no the way the comprehensive plan policies work is that the county must protect wetlands and habitat, and they establish the process for doing that. And that process is a combination of their development standards as well as the permitting process. So those protective measures will still apply.
So it is, in your opinion, this protection for the wetlands and the natural resources is going to be done at the permitting level? Is that where the protections are going to be done?
Yes, it flows, it starts with the comprehensive plan that requires the protection of those resources. And we can go through those conservation element policies, but I testified to them earlier.
Sure.
And those call for the permitting process to protect wetland resources, wildlife habitat, listed species, et cetera.
But when you're doing comprehensive planning on a landscape level, which is what you do with your comprehensive plan, is there no analysis that would be needed to no data or no analysis of what I don't know how to say this clearly. The wetlands, the effect of withdrawing properties out of a natural resource area or possibly increasing the density on an area that could have wetlands. There's nothing at the comprehensive level as far as analysis or study or data that should be done at that time? Should it all be deferred to the permit level?
Well, we already went through the statutory requirement that the analysis consider the character of undeveloped land, and that was under section 163.3177 and the data and analysis requirements. There's no specific requirement under the statute that you consider the adjacent lands, but I would simply testify that the character of this property indicates to me that it's suitable for urban development, and that the impacts of urban development certainly can be mitigated through the permitting process.
What type of land uses does the mixed-use suburban, the future land use allow?
It allows residential, single family and multifamily, and it allows commercial and office uses. non-residential uses.
So and we said the density was 25 dwelling units per acre. Do you know the intensity of, or like what is the highest zoning category that would implement mixed use suburban?
Well, the zoning, if once they provide wastewater to the site, the zoning could be at 25 to the acre. And the intensity that you mentioned, it's limited to 0.4 under the land use category, under the mixed use suburban land use category.
0.4, I'm sorry. How,
The
for,
floor area, 0.4 floor area ratio.
it's not 1.0 floor area ratio for mixed use suburban?
Not for where the property is more than a half mile from an arterial.
Is there something, you've mentioned this a couple times about being limited to development density because of things in the comprehensive plan? What is it in the comprehensive plan that is limiting the density? I know you talked about the zoning limiting, but the zoning is in the land development code. Is that correct?
That's correct.
So what is it specifically in when we're considering a comprehensive plan amendment that limits this future land use in the comprehensive plan?
Well, you go to the mixed use suburban designation.
If you look at petitioner exhibit 29, that is the chapter 7 of the comprehensive plan, and I can share that too. Maybe.
Mr. Metcalf, if you look at petitioner's exhibits and go to the PDF page of 1516, which is petitioner's exhibit 29.
I'm sorry, I have the wrong one. You're right, I'm sorry. Okay, here's mixed use suburban on the screen if you can see it. There's a little bit more behind here. We're not waiting on me, are we?
Oh, I'm sorry.
It's fine. I just want to make sure no one was waiting on me.
So yes, that shows the maximum intensity at 1.0 floor area ratio.
Okay, so is it your testimony that a commercial use 1.0 floor area ratio means that basically the building floor area could equal to the lot size? Is that correct? Is that what 1.0 floor area ratio means?
Yes, except it can be in any configuration.
Right, could be
So-
stories, or yes, okay. So in your opinion, is that an appropriate, say a retail store of with a floor area ratio of 1.0, is that compatible with a conservation neighborhood, especially in this area, in an environmentally sensitive area? Would that be compatible?
Well, sure, because I mean the configuration of that 1.0 could be in a 2-story, it could be in a 3-story. The reality and the reason that I calculated it as I did in my traffic analysis is that if you don't do, and I think I testified to this earlier, but if I didn't, it's important for the record that the resulting cap, the cap that you would have to address in developing the property would have to take into consideration the parking. And so from a parking perspective, the maximum allocation that you can ever achieve with on-grade parking is 0.4. And so to achieve a ratio of 1.0, you would have to have structured parking. That's the only way you can ever get above 0.4 floor area ratio because of parking requirements. And so as a practical reality, you're really looking at 2 scenarios. Would there be a single story developed at 0.4 floor area ratio, or would there be structured parking to try to develop beyond 0.4? In this marketplace, and in my opinion, it's just not reasonable to assume that you would have structured parking. The economics just don't work. Structured parking doesn't really begin to work until you get up to typically about 5 or 6 stories, unless you're in a really expensive market. I mean, there are marketplaces where, you'll see structured parking with maybe 3 to 4 stories, but those are high-end properties. In this more rural setting like this, I mean, you just never do a structured parking scenario. So you have 0.4 floor area ratio as the practical limitation, and then you'd have parking along with that, and that would be your development footprint. And again, in a mixed use scenario like this MUS calls for, you're going to have a percentage of the site used for residential, a percent used for commercial if you were doing a mixed use development.
If you're in the mixed use suburban future land use, you do not have to do mixed use. You could still do either residential or just commercial. Is that correct?
That's correct.
So there could be a possibility that a commercial building could be next door to a conservation neighborhood property. Is that correct?
Yes.
And it's your testimony that that would be compatible?
Sure. I mean, the stormwater treatment, whether it's commercial or residential, would be the same type of stormwater treatment.
Okay. And in your opinion, you did say that the subject property was in a flood zone A. Was there any analysis that was done as to the suitability of a future land use of such intensity and density in a flood zone A area?
as I previously testified, all that means is that you have to place enough fill to achieve the required elevation, and that's typically not that's not a constraint. It's not a V zone where you have to go through the expense of putting the structure on pilings. In an A zone, you simply add a little bit of fill to the grade. So that's, but as I testified, if there's a wetland in this area, it's going to be in the same general area that we're seeing the flood zone A, the flux hydric pinelands that we cited in our flux map, and in the area where the flood-prone soils occur. So that, I would expect if that turns out to be saturated soils in there, it could be jurisdictional, but it's a relatively small part of this property.
Okay, I'm going to direct you to Intervenors Exhibit 2, Bait stamped 0124. I can share the page also. This is, we were talking about impact on natural resources. I asked you if Escambia County staff had done, prior to you being involved, if they had done any analysis on the impact to the natural resources. This is the section where they did their analysis.
Right, so it looks like there's discussion, or you see subsection C dealing with the natural environment at the bottom of the page. And then they have their summary analysis at the end of that.
So the summary just says a general delineation of existing wetlands was part of the original design of the sector plan. Once a project is proposed, an application submitted to the county, such proposal will be reviewed and must receive approval through the site plan review process. So they did not do an analysis, is that correct?
Well, no, I mean, I don't think that's correct. They refer to, it's a summary statement. They refer to the wetlands that were identified in the sector planning process. But the county in their evaluation took the position that those types of analyses would be done in more detail when there's an actual development project. That's what their application process calls for.
Okay.
That doesn't change whether the amendment's in compliance or not.
So do you agree that that's a proper process or a proper way to handle a future land use request, to wait until development to do the analysis?
If I were advising the county, I would advise them to do an appropriate level of analysis to demonstrate that they've considered the character of the land at the time that a plan amendment has been proposed or adopted. The county's following its procedure that it has set up in its application process. And that's the reason, in part, that we supplemented the analysis for this hearing.
Okay. Real quick, you talked about, do you think in the wording, and we don't necessarily have to go there unless you need to, but do you think there is a difference between a remnant and a fragment? Because it's the chapter 16, section 5 of 16.6 says a remnant or fragment. Do you think that there is a difference between a remnant, as a planner, as a professional planner, and a fragmented part of the sector plan?
Let's look at the exact language.
Okay.
So the last sentence, and this is policy 16.6.1 Romanet V. So the last sentence of that policy says such additions or deletions shall not be designed to create remnant areas or fragmented DSAPs. So the remnant area would refer to, one example I gave earlier is, did you create an enclave in the process? That might be considered a remnant. The other language refers to a fragmented DSAP. So yes, I read those as two different things. Certainly fragmenting a DSAP could result in remnant areas. So, you know,
in your opinion,
opting out a piece of property potentially could create a remnant area, and it could fragment a DSAP. And the example I gave earlier with the hypothetical 90% of the sector plan is opted out through an amendment would, in that example, I indicated that would obviously fragment a DSAP and it would leave remnant areas.
So in your opinion, in a lesser context, because of course we can understand the 90%, but is creating a jagged edge like we have show here in this where the subject property is. Here is conservation neighborhood all around it. In your opinion, this would not be fragmenting the DSAP?
That's correct.
Okay, so could you just, and I heard your example of 90%, but just maybe a little bit of a smaller example. What would be a definition of fragmenting the DSAP for you?
Well, what I would say about let's talk about this particular amendment rather than,
yes,
I gave my hypothetical just to illustrate it in the extreme, but you know, situation you have here, you can see the wetlands. They even as mapped by the sector plan, didn't encroach within the property. That's been confirmed by the NWI wetland map. The designation, the opt-out, if you could just leave that screen
Sure.
where you have it, I appreciate it. The opt-out of this property doesn't disrupt the continuity of those wetlands. It also doesn't result in a fragmented situation where one land use is not able to access another land use. I think it's important to recognize that aside from this property, if you look at the larger extent of the sector plan, and again, looking at the framework map, but we can even just make the point looking at this map, there's significant regional employment, over 1,000 acres that is interspersed within the wetlands. And the design of this sector plan was never designed to simply make all of the developable areas compact in one location. What they did instead was they generally sought out upland areas to concentrate employment in while preserving the wetland areas. And so you have your neighborhood center that would still be accessible. You have these regional employment centers that would still be accessible. So whether you consider it from an environmental perspective or in terms of the relationship of the land uses, this property simply doesn't affect the function of the sector plan.
So in your opinion, this area over here serving as wildlife corridor, and if this becomes developed as a parking lot and a commercial property or an apartment with or a housing development, that would not cut off the connected open space areas?
No, there's still plenty of connectivity, and as to the impacts to to the resources, understand that you already have land use, very intensive urban land uses in the regional employment center that directly abut these corridors. This is no different.
Okay, let me see if I'm done here. Okay, well, no, I think I can do that another time. All right, going back to your analysis real quickly. If I can find it here. On page 5 of your analysis, so I'm going to stop sharing this. You talk about the evaluation of the plan amendment. And see, that would be Bait Stamp 7, I think.
Okay.
You referenced an LDC ordinance that established criteria for evaluating requests to opt out of the sector plan in that section. So that's the one that we that the commissioners passed to evaluate or address criteria for opting out of the sector plan. So could you clarify your statements to Judge Folks? Are you saying that this LDC ordinance has no bearing on a sector plan opt-out? Was that your testimony?
Well, I don't think my previous testimony requires clarification, but I can restate it. It's in the record already. My testimony was essentially that only the first item, A1, that deals with the comprehensive plan amendment map criteria would be relevant, because the map amendment criteria that one would follow are the types of analyses that the statute calls for that we walked through earlier in my testimony. And I further testified that the remaining provisions are all related to the DSAP, which is not at issue under this plan amendment, because this plan amendment is an opt-out from the sector plan, not the DSAP.
So in your opinion, the county got it wrong having these requirements to evaluate the changes to an existing DSAP, talking about the size in relation to the DSAP and things like that? Is that?
No, I didn't say they got it wrong. I said it was perfectly fine that their local regulation called for additional criteria for the county to consider.
Okay.
I simply made a distinction between those local criteria and the statutory requirements that don't look to or require an evaluation of the land development code in determining compliance for a plan amendment.
Okay, I understand. Okay, in page 6, and I'll have to look and see which one that is here. Let's see. Supplemental data and analysis. So that's Bait Stamp 0008. You said in your report in the first paragraph here that these plan amendments are similarly situated and comparable to other designations in the sector plan as far as property density and intensity. Did you do any type of detailed analysis of this? And if so, where can I read this to back up your claim?
Oh, just look at the regional employment center that I was previously testifying about.
So, but did you do a detailed analysis, or you're just talking in general terms?
No, I compared them. I reviewed them and compared them.
In this report?
I made a summary finding in my report, but I'm happy to walk through and compare them and look at them together if you want.
Okay,
I specifically state in the second sentence that they approved extensive regional employment centers, as well as high density, intensity, mixed use town centers and village centers. So I specifically mentioned 3 different land uses there.
okay. And your testimony is that that these plan amendments are comparable to the regional employment district?
Yes, that's a very intensive category.
In your second paragraph, you said that the applicant has not proposed a specific development project, but didn't the applicants in their application clearly establish in their application letter that they were wanting to do some type of subdivision development, and that's why they were asking to be removed from the master plan?
No, I think they said that they were not proposing, and I believe they actually had to fill out a form that said they weren't proposing any particular development project, and that was the county's finding as well.
But then there was also, okay, well.
Just because someone might consider at some point that they want to do a subdivision, that's greatly different than having a development proposal that they've submitted to the county. I mean, I don't think there's too many people that have vacant land that at some point aren't thinking about what they might do with their vacant land in the future.
Okay, so if an applicant says when they come in for removal from the master plan or a comprehensive plan change, it's appropriate, if they say that there's no development, to not do the analysis to the highest amount that future land use would allow?
Well, I think I've already given an awful lot of testimony on this point about my opinion as to when it's appropriate to do the maximum analysis, and that what the county staff did, I believe, is in recognizing the zoning is simply recognize that there's a wastewater constraint that would limit the development to 4 units per acre until such time as wastewater services are extended to the property.
So when you say there's a wastewater constraint, is that not saying that there's not enough capacity for this future land use category of mixed use suburban, that there's not an adequate supply for that future land use?
Yeah, I already went through that analysis and presented the capacities and demonstrated there's sufficient capacity. When I'm saying there's a wastewater constraint, is I'm saying the property is not currently serviced by wastewater.
Going to the water, you say that ECUA at some point will have to come in. Obviously you had a conversation and you discussed this, but are you saying that ECUA can step in and take away the franchise from Farm Hill?
The way that normally works is that if under the statute, if a utility is not capable of providing a requested service and another utility is capable of providing it, then that second utility has a right to pursue and to establish a service area. Yeah, if you're going to claim a service area, you have to be able to provide the service.
But the franchises are granted from the county commission. Is that not correct?
No, I don't believe that's correct.
Okay, do you have any documentation to show that ECUA is planning for increased capacity in this area? besides
When you
your,
say increased capacity, I already testified that they have sufficient capacity. The question would simply be, the extending the wastewater line approximately 3/4 of a mile, which
and
is routinely done by utilities.
And again, is there any current plan that you have documentation of that ECUA is planning to do that in this area?
What ECUA advised me was that they were working on an updated master plan and that they intended to specifically address how they intended to expand their system to address the sector plan area.
Okay, but there's nothing directly, no plans yet.
Right, but what you have to understand is it's on a demand basis. So, I mean, if a property owner requests service, then that property owner can pay the fee to extend the pipe to provide the service.
Why is it a requirement in 163.3177 then to make sure that there is sufficient capacity for public facilities and utilities and things like that? If you're saying, you've said several times that there's no concurrency, so it doesn't matter, but we're going to do the analysis anyway.
Well, my statement about concurrency was with respect to schools, transportation, and recreation. The statute requires that the elements are coordinated. And as part of that, there's an intergovernmental coordination element that requires that the county coordinate with its service providers. And so there's the intent there is that as the county approves land uses, that there's coordination occurring to confirm the extent of the system, the available capacity, and that there's a process for going forward in order to stage those improvements. And that's for a utility, that's all handled on the utility side. That is, the utility itself as an enterprise fund would work with the property owner to extend the services. And so, yes, there has to be coordination. Ultimately, there has to be available capacity, but that capacity doesn't have to be available at the time of the plan amendment. That's not what the statute calls for.
There is a provision in the comprehensive plan, FLU 2.1.1, that talks about infrastructure capacities and talks about concentrating the most intense development permitted in areas with sufficient central water and sewer system capacity. Would this approving mixed-use suburban in an area that does not have capacity be inconsistent? It's FLU 2.1.1, and I'm not sure where it is on the exhibits. Infrastructure capacities. Let me see, I think it's, I have it on a printed version, so I'm not sure where it is, but it's in the, here it is. I think this is it. Okay, I think it's in 7.9 of the comprehensive plan. So let me find that real quick. Chapter 7, which would be petitioner exhibit 29. This says 7.9. Oops, it doesn't, I don't have it all in here. Maybe I need to go to the, Let me go to the interveners real quick. Intervener Exhibit 16. I apologize. Intervener Exhibit 16, bait stamp 0956. Objective Flu 2.2, provision of public services. The objective is promote orderly and balanced growth and development as a fiscal management technique. But that next policy there, Flu 2.2.1, the policy is for location, public facilities and services will be located to minimize their cost and negative impacts on the natural environment and maximize their efficiency. Cost alternatives, impacts on the environment, and levels of efficiency will be discussed during the design phase and bid process. Oh, that's not what I was reading, though. Was that what I was reading? No, I'm sorry. I'm sorry. It was 10.2. And I don't think that's in here. I grabbed the wrong page. And I don't know if it's even an exhibit, but it is a comprehensive policy. It's under infrastructure, I believe, INF 1.1.11, required new service connection. I'll just go ahead. I think I grabbed the wrong paper. Let me just leave that one because that's that's what wasn't even what I was reading. I was reading Flu 2.1.1. I just got off on the wrong one. I'm sorry. Let me go on to the next question so I can finish. Okay, the school, your school capacity, you did not address any of the local schools. You used let me unshare this. You used a global calculation figure. We did hear that Tate School and Kingsfield were at capacity. When you're doing this type of comprehensive planning and you're talking about school capacity, obviously you're talking about the capacity for the road in the local area. We're talking about planning. We're not talking about concurrency. You're planning for the facilities in that area. Why didn't you take the figures? And I do know that the estimates in the latter half of the chart are off. On November 13th, the school board removed their 5-year plan, and it's on the agenda for the next meeting because those were state estimates for future capacity. And obviously, like Mr. Beach said, it's not going to make sense that a school at capacity without building a new high school is going to go down. But for the purposes of your testimony here, why did you not do an analysis on the schools? You did mention the schools. You mentioned Tate, Ransom, and Kingsfield Elementary, but you didn't talk about, their capacity levels at this point. I heard your explanation where you said that the school district does it and at a district-wide level.
Ms. Rogers, you asked a question, allow Mr. Metcalf to answer it instead
I'm
of
sorry.
telling him what he testified.
Okay.
Well, I can repeat my earlier testimony. It's not going to change.
No, you don't have to. That's why, let me focus my question. I'm sorry. Let me focus my question. That's what I was trying to do, so you wouldn't have to repeat it. Are you aware that there are limitations to how far an elementary school student can get bused? So for instance, when you're saying that you can calculate this on a district-wide, if a school is at capacity, but there's capacity on the other side of the county, why wouldn't we just, on a planning level, look at the schools like the planning board member, the liaison, the school board member said, this school is at capacity?
Well, that's a policy decision that the district and the Court of County Commissioners has made together. They could have chosen to adopt concurrency service areas. They did not. They could have chosen to not have a choice program. They did not. They have choices that they have to make that ultimately impact how you plan for schools. And they've chosen to evaluate schools on a district level. And that's how the statute actually recommends that it be done.
So, but I'm saying for a professional planner like yourself, why wouldn't you use the figures for the schools in the area?
Because I follow the statutes.
Okay,
There's no level of service standard. There's no service area for these schools that have been adopted into the comprehensive plan. It is a district-wide service. And the school district, as I previously testified to, is subject to a lot of different constraints.
Okay.
When people make choices to bus their kids 1 mile to where they can take the bus and they can do that up to 2, the way the process normally works is they can walk up to 2 miles and then they bus them beyond that distance. If parents decide they want to drive their kids halfway across the county and a new school opens up and it's very popular and they immediately fill up, well, that's because they made the decision to allow a choice system.
Okay. In one of the exhibits I have is petitioner exhibit 42. We don't have to go there unless you want to. It is passed as an ordinance every year. It is the 5-year schedule of capital improvements. There's nothing on that. That is it true that there's nothing on there for Kingsfield Road to be improved on that 5-year schedule? The CIE.
You would have to show me what you're talking about.
Okay, petitioner exhibit 42. Okay, this was passed in May of 2020. It's just an ordinance they pass every year. Instead of putting it in the comprehensive plan, they put the 5-year capital improvement plan. But I've been through this and I see nothing that is funding. They talk about the transportation planning organization documents, but there's nothing in here that's funding Kingsfield Road. So I guess piggybacking on Miss Blackwell's question, is there any type of funding that's identified for the construction or improvement of Kingsfield Road?
Well, I think I already testified, and we can go through the tables to confirm that what you're testifying about in your question is accurate. But let me just assume for the moment that what you're saying is correct. This is a 5-year capital improvement schedule. The availability of long-term improvements wouldn't necessarily be reflected in a 5-year capital improvement schedule. That's the reason you have 2 planning periods. But I think more important to the point is that the county's gone through, they're going through the design process, and then once they've completed the design work, they're going to start their construction program. But even if they don't, if a landowner wants to front end the improvements to the roadway, they're certainly able to do that. And that would be one of the, as I mentioned, one of the prerequisite conditions to urbanize beyond 4 units per acre, along with the provision of wastewater. And so a 1/4 mile, if a developer wanted to build, we done the calculation as I believe we at 25 units per acre. We had indicated 1,953 units. If a developer wanted to build something that large, they would be able to front end and build the capacity for that quarter mile, because that's all we're talking about here. It's about a quarter mile to reach the Westmark property.
With no concurrency, there is still a constraint on development for lack of road capacity? My understanding was there is no constraint on.
The county includes policies, the comprehensive plan includes policies that require a safe design. So concurrency is about capacity. A safe design is also required. And so if someone wanted to come forward and urbanize the property, they're going to have to demonstrate that they would have a safe access provided for the property. And so that, again, that's a funding choice that a developer or a homeowner landowner can make.
Okay, I thank you. And I think I've been through, let me just check this one other here. I think that's it. Thank you, Mr. Metcalf. Thank you very much.
Thank you.
Before redirect, let's take 5 minutes. Okay? Am I on mute? Is everyone in agreement?
Yes, you're on.
Okay. 5 minutes.
He's unmuted. No, he's
No,
not.
they're on
He's muted.
Okay. Are we back?
Yes, the county's back. I don't know about Ms. Fox.
We're back.
I don't see it in the comp plan.
Okay, we need Mr. Metcalf.
All right, bye.
Your Honor.
Oh, there he is. Okay.
Thank you. Your Honor, are you ready for redirect?
Let me find my court reporter. There he is. Okay, back on the record. Redirect, Ms. Fox.
All right, Your Honor, I have no further questions for Mr. Metcalf.
Okay, you have any questions, Mr. Pepler?
No, Your Honor. Thank you.
Okay, thank you very much, Mr. Metcalf.
Thank you.
Ms. Fox, any other witnesses?
No, Your Honor, the interveners rest.
Okay. Ms. Rogers, it's time for rebuttal. Do you have any rebuttal witnesses? Or any of the three petitioners want to give rebuttal testimony?
Judge, before Ms. Rogers answers your question, there's one issue I wanted to bring up with the respondents' exhibits. Apparently when we tried to bait stamp them for easy reference, the map programs did not communicate well with the Adobe program. So there's some missing, the maps are either shrunken or they're off by a certain section. So my legal assistant right now is reformatting all the respondents' exhibits so that, you know, there's no missing maps or compressed maps or any missing sections of the maps. And we'd like to submit those to Your Honor at a later date. Hopefully they'll be done today, but, you know, within a week or so, or 5 days. And then we,
Okay,
Is that-
are we talking the entire exhibit, all the exhibits?
right, just to make it
One through 30?
correct. Whatever our,
Remind me, what happened about 31 and 32? I have them
let me take,
bracketed, but I don't have a notations beside your exhibits 31 and 32. Well, 32 would be the same as 1, because that would be Mr. Metcalf's document.
right.
And what was 31?
31 was showing the removed properties from the sector plan.
Did I not receive it?
Check notes here.
Hmm.
Your Honor, there may have been a question as to where it came from, because I don't know where that came from. What application, what amendment?
That was probably prepared by our development services employees, either Juan Limos.
Okay, well, well, let me,
It's, it's really for
okay,
demon.
well, let me not, well, I have this question then.
Okay.
I mean, have we been referring to Bates stamp numbers for your exhibits? Would those be like incorrect in the entire record?
No, it's only the formatting usually of the maps will be off. And so when they're reformatted, certain sections that are sort of disjointed that then would fit in with the original map. In other words, there was some labeling that took place. Like if you look at Exhibit 31, those labels would be off by maybe a ½ inch or so. But with the reformatting, then they would actually show like the location of the Westmark property in a proper location.
Okay, well, I'm still confused. But what I would suggest is whatever it is that you're gonna send to me, that you make sure the other parties get a copy.
Correct.
And they can raise any issues other than what they've already raised. Because I'm not understanding why it's an issue. I did notice that there were some overlapping labelings.
Mhm. Correct.
Is that what you're talking about?
Right, and there's one exhibit. I made a note of it. Hold on a second.
Okay, well, you go ahead and do what you think is necessary to make the record more clear.
Okay.
Send that thumb drive to me and make sure the other parties see what changes you've made, or maybe what you can do is in the cover letter that comes with the thumb drive, your paralegal can explain.
Okay.
And so that will be part of the record.
All right. Just for an example, Your Honor, I mean, you don't have to turn to it now, but at Exhibit 23, at Bates number 498, what's supposed to be a map is like the size of a pinhead. And so obviously you can't read it. So that has to be reformatted.
But is it in the size of a pinhead and I can't expand it in Adobe Professional?
You could, but this pixelation, we tried it, and the pixelation, I mean, it goes way off the page.
Okay. Well, you do what you think you need to do, and then just send that with a cover letter. Make sure the other parties get copies.
All right, thank you, Your Honor. And with that, the respondents rest as well. So.
Okay. Ms. Rogers? Rebuttal?
Ms. Blackwell, do you have anything?
Yes, I do. Thank you.
Okay, Ms. Blackwell, remember that you're still under oath.
Yes, Your Honor.
Go ahead.
Okay, so first, there's the testimony of Terry Malone. And contrary to her testimony during this hearing, the three levels of recommendations for remediating the safety hazards in the petitioner's Exhibit 43, the safety study of 2017, those safety hazards have not all been completed. On further questioning, she admitted that only the relatively minor remedial actions like painting, patching, and putting up some white posts had been completed. The two categories of more serious and costly problems, she then admitted, have not been completed, as William Beach testified and as his photos showed. She also claimed that the project was at 90% design, and I think she said with permits applied for. I have an email from the county's engineer for the project, which says the project is stalled at 60% until the right-of-way is procured, which is under negotiation. She also says they will not apply for permits until the right-of-way is acquired. So that testimony was not credible, at least initially. Okay, so Mr. Metcalf told us that he has not driven West Kingsfield Road in order to appreciate how substandard the road actually is. It is more than substandard. It is a documented dangerous road. He also does not appreciate the unusual level of growth that we are experiencing in this part of the county. The standard 2% escalation for normal growth on a somewhat substandard road in a neighborhood with an average rate of growth is not an accurate reflection of what is happening here. And the exhibit I would reference here was Petitioner's Exhibit 43, West Kingsfield Road Safety Study of 2017. Then Mr. Metcalf, Intervenors Exhibit 1, Attachment 3.1 of Mr. Metcalf's report, and Intervenors Exhibit page 27. There's an aerial view of the Westmark property with a diagram of the West Kingsfield Road Extension Road that is planned to go through their property. The road diagram is cut off just as it reaches a diagonal clearing in the lower left-hand corner. Mr. Metcalf testified today that his analysis is based on the Florida Alabama TPO plan for the extension of West Kingsfield Road west all the way to Beulah Road. Attachment 3 of the report, that aerial view is actually showing it ends just before the road ends. That is the end of the entire project. So he thought it was just the 60% mark as far as design, and they would continue on down the road. But that's not true. And it took me a while to figure that out. I just figured it out since our last hearing. And I would go to Petitioner Exhibit 46, sheet number 3, which Ms. Rogers referenced and I couldn't find a minute ago. So this shows the entire West Kingsfield Road Extension project at the 60% design phase before right-of-way and permits have been procured. The Escambia County Transportation Director, Christine Fanchi, said last week that the county did not have the funds to complete the entire roadway as laid out in an earlier preliminary engineering study. So they decided to go part way and hope that the state would bring a road up north to meet it from a planned Beulah interchange on Interstate 10. But I also talked with the FDOT Beulah Interchange Project Manager, Eric Sagers, and he said FDOT has no plan to build that road up to the end of the West Kingsfield Road project as it now stands. So, and Mr. Metcalf is correct. The Florida-Alabama TPO does have an extension of West Kingsfield Road all the way to Beulah Road on a plan. It is listed as a project that is needed. And he told us today that he based his analysis on that road that they plan. On Tuesday, Florida-Alabama TPO Executive Director Austin Mount said it is not on their cost feasible list on the 5-year work plan as approved for funding. He said the TPO is meeting today and will make a few minor adjustments to the 5-year work plan. And then he said, but I guarantee you 100% it will not be added, he said in reference to that extension. Due to the COVID pandemic gas tax revenue drop, he said the state is looking to cut $1.5 billion from projects that have already been approved for funding. And the other consideration is that the Westmarks were to build their own entrance road, which this extension really amounts to. It is a road to development as it stands. Until it were to someday get manna from heaven and be completed all the way to Beulah Road, it is just a road to subdivisions. So if they were to build that, that would not relieve the traffic on Kingsfield Road. It would not keep the public from having to travel those 90-degree turns and then go from what the roadway that Mr. Metcalf called an urban, what did he call it? Urbanized area uninterrupted flow highway. They would have to travel on the part that is a rural local road. It has lower LOS standards, which he did not use in his analysis. So his analysis is based on a road that's not going where he thinks it's going. And for some reason, that whole file seems to have just disappeared from the county's website today. I've gone there many times, but just now I could not locate it. It has plans, etc., about 8 different files that somehow that is not, you can't call it up. So let's see. So I just would say in conclusion that considering the tenuous state of funding and construction for a West Kingsfield Road extension, and that it will not even go to Kingsfield Road, analysis of the most intense use should not be based on a non-existing road with no construction funding, instead of the road as it exists and will be used for many years to come. Excuse me, and I have an email from Mr. Sagers also to be added, which confirms what I said about there not being a project on their schedule to meet the shortened county extension road. Thank you, Your Honor.
And Your Honor, I did submit for rebuttal, which they reference what Ms. Blackwell was referencing. So I submitted those on the e-file system. One of those was not anything she referenced, but it was the bigger document that had the dates on it for the projects, whether they were already done, approved. So that's another one on there. So just briefly, I think we've, covered a lot of things on here. The reason why we're involved in this is because we are citizens that are just concerned about the infrastructure. We're concerned about the flooding in our community. We are concerned about overdevelopment. We are concerned about public services not being available, and because we can't keep up with the population demand. There's lots of arguments that I will make in my proposed recommended order, so I will save that for then. But This original comprehensive plan was based on data and analysis. There were population projections. They planned the character of the undeveloped land. There's lots of environmental studies that you can see in the foundation documents. Over the past couple months, I am so much more convinced that maybe this sector plan was done at the behest of development that wanted to move into the central part of Escambia County, but there was a lot of work, there was a lot of public visioning, there was a lot of public meetings, and yes, it is an unusual one. I live in the sector plan also. I know that not everyone understood. I did not understand at the time, but I believe that there was planning done and that these conservation areas are not random. I believe there was an initial long-term, and I will be able to, talk about that more in my proposed recommended order. There was a long-term conceptual map that was done, but there's a process that's outlined in Chapter 16 and also in the DSAP document about honing in on the environmental resources and things like that to come up with that final DSAP map and those land uses. And so that's why you see those changes. And I do believe that the DSAP was adopted, as we saw, as a comprehensive plan amendment. And so that makes it different than the newer ones that are being developed and can be changed locally without state oversight. I believe that it's the master plan and the DSAPs that were adopted into the comprehensive plan were found to be consistent with the rest of the comprehensive plan. And I think that now anything done to change the comprehensive plan, which we know is a long-term vision, it's not a local daily thing that we're supposed to change all the time, that we still have to be consistent with that. There is another plan in our comprehensive plan. It's called the Navy Federal. Navy Federal is a credit union in our area, and they have a master plan, and they have the same wording about if you want to remove a parcel from the Navy Federal Credit Master Plan, you have to still be consistent with the plan that's in that area, and that it has the same wording as the DSAP wording, except for it actually spells out that last word. Instead of saying be consistent with the plan, it says be consistent with the Navy Federal Master Plan. So I know that was intentional in there. The rest will be legal arguments. We have the staff, we have the volunteers that could have done the resources to say, is this a good environmental? There's lots of testimony that we gave you about the importance of the environment. Escambia County, when they first had the first request to opt out of the sector plan, they discussed repealing the sector plan, but they decided it was worth keeping. And so I feel like we're suffering death by 1,000 cuts, and there is no comprehensive planning for what's going to happen. Everyone's going to opt out, and they're going to say, well, it's just 80 acres. It's just 100 acres. By doing it in these bite-sized chunks, we're there, and they're only coming out of the conservation neighborhoods, as Mr. Jones confirmed, or Mr. Lemos, it might have been. I believe that these amendments, I believe that the evidence shows that they made a policy decision, the county commission, they made a policy decision, and then they figured out a way to accomplish it. So the decision was not made in reaction to the data and analysis. The data and analysis came afterwards, thanks to the interveners who provided it. This was not something that was thought out, and they did not react appropriately to it. So the rest, there are 4 documents that we submitted as rebuttal documents. One of them is a capacity document for schools that, I mean, this is going, my testimony right now is going to be hearsay, but I guess I get a rebuttal. On November 13th, I went to the school board and I said to one of the school board members, this is what people are using for development approval. They are using the 5-year work plan. I said, how can high schools be at 99% capacity and 5 years from now, they're going to be below and you have no scheduled high school to be built? And the school board member, to his credit, said, that's not right. We're going to look at it. He looked into it and he found out those were state projections. I'm not sure where the state is coming from it. The school board is possibly going to appeal those because they can't ask for school funding to build more schools if they're not even close to capacity. So I believe, that's not Mr. Metcalf's fault. That's not anybody's fault. I believe it's just a mess up. This is what is on the county website right now. This is the corrected figures. Here's Kingsfield Road. We're looking at available seats. They have none. Ransom does have 199. Ransom has been at capacity before, but they do have 199 seats. Tate has negative 120. Those are the 3 schools we're talking about. And you can look here at the overcapacity schools. This is a corny little thing that accompanies that above chart. And it tells you Tate High School, Kingsfield Elementary, these are the ones that you can't transfer into these schools because they're over capacity. So that's one of our rebuttal things. This is the email from Liz Bush, who is in charge of the project for the West Kingsfield Road extension. And this verifies what Ms. Blackwell told you, that we are not in 90% design. They have not acquired the properties. They haven't acquired the permits. So she confirmed that. And so Ms. Malone's testimony was incorrect. This is the development review, and it's a very bigger file, so you can look in closer, but just so you can see, it is dated over here. And it talks about what's permitted. I'm gonna have to pull this up. It's a big file for development, so it's better than the one that I had submitted before that was undated. It talks about the development review committee projects from July 13th, and it does go to October 20th, but those would be probably the pending ones. So you could still see what's been approved. And then the last one, this is the one that Ms. Blackwell also referenced. She spoke with Mr. Eric Sagers, where he confirmed that there is no plan to do an extension on the part of FDOT. I also have an exhibit that I think is out there pending. And I would like it to be reconsidered because the data was available. I just put down what day I accessed the website from academic things, and it shows you, if I can find it real quick. Here it is. 51, petitioner exhibit 51. It's just a 2-page exhibit. Shows you the website. It shows you when I accessed it, but this data has been around. This is their plan. Mr. Metcalf, I think in his report, or others have said that there's going to be a Beulah interchange built, and we're all awaiting that. Here's the subject properties are right about here. Here's the 90-degree Kingsfield turn. And this is where that interchange is going. This is the Beulah Road that we're all talking about. There is no project to come across here. Just to be sure, if you go down to the second one, they talk about projects in the area, and the only projects in the area are on Interstate 10, another one over here, and then one on 9 Mile Road. So
what exhibit is this that we're looking at, Ms. Rogers?
51. This is one that I think someone complained was post dates because I said when I accessed it, but this data existed for a long time. This is FDOT's plan. And my reason for sharing it is just to show you there is no plan from FDOT's point of view. We know the county has the plan to go out here into the wetlands and stop right here past the gas line, wherever that is over here. But there is no plan for FDOT to fund the other half, which we've all been told it was. So I don't blame anyone.
I have that document as not admitted into evidence.
Right. Well, I'm asking to appeal that because so many of Mr. Metcalf's were the similar situations. He didn't access them till later, but the information, existed before the adoption date.
And what's your proof that the information existed?
Because this is a highway plan. I mean, they didn't just come up with this plan. This is they're having public information on it, but anyone in this room, including the attorneys, can tell you that we've been awaiting the Beulah interchange for a long time. So
Can I intercede here?
Awaiting it is not the same as a plan on the books.
right.
Mr. Pepler or Ms. Fox, remind me of why I did not admit Exhibit 51.
Let's see.
Because, she's testifying extensively on it and it's not admitted, which means basically I'll ignore her testimony about it because it's not evidence
I think it was for that
at
reason.
this point.
The reason is that there was no indication that this data would be available or was available on June the 4th, the date of the adoption hearing. And I thought there was also an argument about relevance when we're talking about the withdrawal of the 3 parcels, Westmark, Arnold, and Jolly from the Kingsfield area, as to the relevance of a planned interchange at I-10 and Beulah Road.
Your Honor, I have something to say about the relevance. The email that,
Ms. Blackwell,
yes.
you had your turn.
Oh, thank you. The email that Ms. Rogers just showed you from Eric Sagers.
Ms. Blackwell,
What?
you had your turn.
Oh, I had my turn. I just want to tell you the relevance that
This
Mr.
is Rogers' exhibit. I want her to tell me why she wants it in evidence.
Okay, well, I was just going to tell her that he talks about that loop right
Well,
there.
I can tell her. So
Okay.
in rebuttal that we just submitted to you from the gentleman, Mr. Sagers from
And
FDOT.
by the way, those emails, just because you uploaded them to the DOA website does not make them evidence that I have admitted
No, I
in this
understand.
hearing. So you have not asked for them to be admitted.
Okay. Well, I'm sorry. That's what I thought I was doing now. I was asking to have those admitted as rebuttal arguments. But to me, the relevance of this is because we are talking about plans that the state and the county have that are non-existent for an extension to relieve the traffic and the traffic flow that's on Kingsfield Road. And I think that that's important. So
Well, I understand your point. Mr. Metcalf says he relied on a certain, what was it, TPO document. I think beating the dead horse that the other folks' plans don't show it doesn't change the fact that that's what he relied on.
right. Well,
If you want to argue that him relying on that alone is not appropriate, you can argue that in your PRO.
okay. What I guess what I'm arguing right now is they had an October 2020 traffic exhibit for the interveners, and we allowed that because Mr. Metcalf said, well, some of the information was here before, some of it was newer, and so that was allowed into evidence, and it was dated October 2020 on the front, printed, and this is just a website that was accessed after the date. So I just
Yes, but Mr. Metcalf could tell me, along with other supporting exhibits of the interveners, when that data existed and prove that it existed prior to June 2020. You are just telling me that this information must have existed because it was on their website or it is on DOT's website. That's not enough information for me to make a finding that this document exists and contains data prior to June 2020.
Well, the only thing I could tell you is it's been talked about, and this project has been talked about in the community for years, and it's a 10-year project out. But you're right. There's nothing I can say if you don't believe that. There's nothing I can say.
Okay, so petitioner's exhibit 51 is still not admitted into evidence. Let's deal with these documents that were uploaded today while we were in hearing, or just before. There's a petitioner's rebuttal exhibit 1, an email dated November 16, 2020. Do we have
Okay.
any objections to petitioner's rebuttal exhibit number 1?
Yes, Your Honor. The pretrial stip is very clear, or the pre-hearing stipulation is very clear, that every party has to list their exhibits, whether for substantive, corroborative, impeachment, or rebuttal, to be used during the course of the hearing. And obviously, if this was filed today, it certainly wasn't listed back in October. So for that reason, I think it should not be admitted, as it wasn't properly wasn't properly listed by the petitioners.
How would we know, Your Honor, that we needed to rebut testimony that happened in the hearing on November 12th? How would we know that we would have to submit something? This is in rebuttal to testimony that I thought that's what rebuttal was. And I may be wrong. I've never done
What are
rebuttal.
we rebutting?
We're rebutting Ms. Malone's testimony.
Rebutting.
This is rebutting Ms. Malone's testimony that the design plans were at 90%, she testified. And she also testified that.
Really? That's what she testified?
Yeah.
Yes, ma'am.
Yes, ma'am.
Well, Mr. Metcalf testified it was at 60,
Yes, he did.
and all the plans that we have show that it was at 60, that it is at 60.
Correct. But she is the transportation planning organization person, and she testified that it was at 90. She also testified that the permits have all been received, I think she said, but at least applied for. So Ms. Blackwell.
Applied for, yeah.
I'm not sure about that. But anyway, we'll see when we read the transcript. But the fact is, that's what the pre-hearing order says, that rebuttal exhibits have to be supplied as part of the exhibit list. And I understand when you say, how can you know? But the fact is, that's the law in the state of Florida. Rebuttal exhibits must have been revealed. And I can tell you that usually you know what your rebuttal exhibits are going to be if you take depositions, because then you'll know what folks are going to say and may say in hearing. So I'm not going to allow petitioner's rebuttal exhibit 1.
So could you clarify for me, Your Honor, what this rebuttal time is then? Is it just a closing statement basically then? It's not for rebutting?
It's a time to provide me with information that rebuts what was presented by the county and interveners.
Okay. Well, that's.
But the law does say you must have your rebuttal exhibits as part of your exhibit list.
Rebuttals to depositions, yes, I
Because
understand
it requires that the parties see each other's exhibits before the hearing, so there's no surprise.
Yes, I understand that.
And I can tell you, the litigators, they're a little frustrated with that, but that's the law in Florida. And so you cannot produce a document and use it as any kind of exhibit, whether impeachment, rebuttal, and all those words that Mr. Pepler quoted from my pre-hearing order. You cannot present an exhibit that the parties have not seen before.
Okay. Well, I'm sorry, I got bad advice. I'm sorry. I assumed if we were in a courtroom, I would be able to hand it to you. You would be able to hand it around and then see if there's any objections. I didn't know.
The Florida Supreme Court opinion that directs that this be the case would also apply in a court of law in the state of Florida.
Okay, thank you.
Judge, with regard to the school district exhibits, basically the chart showing the schools and the capacities, that's really petitioner's exhibit number 22, which I believe Your Honor did not admit at the beginning of the hearing in November because it was based on data dated July 1st of 2020. And the overcapacity school diagram with the caricatures on it and the names of the schools is undated, and that was petitioner's exhibit number 21. And again, Your Honor didn't allow that into evidence because there was no indication as to when that data was acquired or compiled. And again, if they're using as rebuttal, it hasn't been disclosed as a rebuttal exhibit. And then the added argument is that they're based on data that was acquired after June 4th of 2020.
I'm withdrawing all my exhibits because I understand what the judge said. So.
Okay. So for the record, the exhibits that were uploaded to the DOA docket today entitled Petitioner's Exhibit 1 through Rebuttal, Petitioner's Rebuttal Exhibit 1 through Petitioner's Rebuttal Exhibit 4 have either not been admitted or been withdrawn. Okay.
So hopefully.
So you can continue with your rebuttal testimony, Ms. Rogers.
I just hope, hopefully, you know, then we're reduced to hearsay, and I hope that, you know, what Ms. excuse me, what Ms. Blackwell has said could be considered. But I do think that there's enough data in here, and there's enough evidence that we can successfully argue in our proposed recommended order what our position is. So I don't have anything else to say. Thank you.
Okay, Ms. Fox, do you have any questions of the petitioners?
I do not. I do
I'm
not.
sorry, I forgot to ask you if you had any questions of Ms. Blackwell, but no.
I do not.
Okay, Mr. Pepler, you have any questions?
I do not. I think we had divided up the witnesses. I think Ms. Johnson was going to handle Ms. Blackwell. I don't know if Ms. Johnson has any questions.
Ms. Johnson, any questions of Ms. Blackwell?
No, Your Honor, I do not have any questions either.
Okay. I think we're at an end. Very good.
Thank you. Thank you for your patience
Oh, well, thank you.
and your explanations.
I'm sorry, I'm making notes while I'm talking. Don't mind me. Have the parties talked about timing of proposed recommended orders?
No, Your Honor.
Well, I will tell you, because I'm supposed to, that the rules of DOA, which apply in these proceedings, Uniform Rules of Procedure, set out a timetable of PROs being due 10 days after the filing of the transcript with division, which and my recommended order being due 30 days after the filing of the transcript with the division. So those are the rules. Usually the parties talk about whether they're going to keep to the rules or waive the rules An approach can be to keep to the rules as of today, and then based on when the transcript is actually filed, because of course we're coming up on the holidays, the parties can always get together individually or jointly and request an extension of that 10-day time period within which they would file, you would file your proposed recommended orders. Under the case law, that waives my 30 days, but that doesn't, that's neither here nor there. I still try to get my order out as quickly as I can based on my schedule. So do we want to do that? Do we want to stick with the rules and then y'all decide later?
That's fine with me. I don't know what Ms. Fox.
Ms. Fox,
Yes, that's fine with me, Your Honor.
Ms. Rogers?
Just to clarify, 10 days after the transcripts are filed with DOA, then we would have to have our proposed recommended order in?
Yes.
Okay.
And like I said, those are the rules, and it's a short time period, which is why we have no problem entertaining motions for extensions.
Okay.
And I prefer them to be joint, which means the parties get together and come to an agreement and give me a timeline that they feel they could comfortably file.
Judge, I think you
Let's
can
see,
expect,
Ms. Backwell, is that good?
Yes, Your Honor.
Okay.
Whatever you all decide.
Okay, I'm just making sure everyone's covered.
Can
Judge,
I
I
make,
Judge, I think you can expect an motion for an extension of time.
Okay, well, like I said, yeah, we do this enough to where we're probably gonna do that. But like I said, I prefer joint or unopposed, where you have all decided how much more time you need, and then I'll just issue an order granting that time period.
I think we can do that, Judge.
sure.
Okay, well, thank you all so much
Thank you.
for
Thank you.
coming back and your patience with the technology as we all have to deal with this. And everyone did a great job. And I will look forward to receiving the transcript and receiving your proposed orders at the appropriate time.
I guess, Judge, the agency, I mean, the county would order the transcript. Is that usual?
That's normal, but then people make deals that I don't need to know about, about who's gonna pay for what, or
Okay.
share payments of stuff. That's, yeah.
Okay.
But under the rules, the agency, which in this case is the county that adopted the ordinance, is responsible for making sure I get a transcript.
All right.
Also, with regard to those exhibits, even if you get an extended PRO, could you try and get me that amended thumb drive as quickly as possible?
We're going to do that, Judge. Yes. So,
Okay, great. Okay, well, y'all have a great rest of the afternoon and happy holidays.
Yeah, happy holidays.
Hopefully the new year will be better than this year.
it
Yeah,
has to be. Yeah.
yeah,
Okay.
not much of a lift.
Right. Well, thank you, Your Honor.
Bye.
Bye-bye.